On the slopes of Diamond Head. This is Kapiolani Community College. Kulia Ikanu'u, strive for the highest.
Aloha. Welcome to our final session of BLAW200, the Legal Environment of Business. I'm Ben Carroll. Well, we've been going through the law from start to finish. We've last time spent some time looking at the consumer protection, some of our individual rights. And today we're going to wrap up. We're going to look at international law and put ourselves back in context where the U.S. law we've learned fits into the international system, how they interact, etc. But first, let's take a look at our material from last time. Okay, does the common law protect consumers? Does the UCC protect consumers? If so, why are there so many consumer protection statutes? Okay, well, remember we talked about the common law, and in general, the common law pretty much put sellers and buyers on their own. So we had the doctrine of caveat emptor, which meant buyer beware. So it pretty much meant you look at it, you decide if it's what you need, etc. And if you select wrong, that's your problem. Now, although that was the general doctrine, there were some exceptions in common law as well, and those would be for fraud or misrepresentation. In other words, if someone led you to believe something by affirmatively alleging, fraudulently misrepresenting the facts, that's a problem, and there were certain warranties that were made. But in general, you're kind of on your own. How about the UCC? Well, the UCC does not specifically, Uniform Commercial Code does not specifically refer to consumers. It applies to all commercial transactions. But some of the common law warranties as well as some other protections were built into the Uniform Commercial Code, so they would apply to consumers as well as other commercial transactions. And again, that embeds the warranties of merchantability, the warranties of fitness for a particular purpose. The unconscionability provisions are also there. So we've got some protection in both common law and the UCC. But as we looked at last time, there's an awful lot of consumer protection statutes specifically passed to add additional protections, from the Magnuson-Moss description of express warranties to the credit, all the other statutes that we looked at. So why do we have this plethora of additional statutes if we have protections under both common law and UCC? Well, it's because that as products have gotten more complicated, it's harder for people to determine if their injury can be caused to them. And also there were a number of things that happened with the larger industries that seemed to be anti-consumer or not protecting consumers adequately. So that's why we have these statutes that add to those protections. Okay. What federal agency is responsible for regulating unfair and deceptive advertising? What agency concerns consumer products? And what agency concerns food? Okay, so the unfair and deceptive practices advertising, that would be the Federal Trade Commission, again, a very early agency that was formed, and they would take care of that entire area. Okay, with respect to consumer products, Consumer Product Safety Commission. And with respect to food, and also including drugs and cosmetics, would be the FDA, the Food and Drug Administration. Now, there are many, many other agencies that we've talked about. There are hundreds of federal agencies, and most states also have scores of agencies that handle various areas. So we've just hit the real big highlights here. There's an Environmental Protection Agency involved in this. Health and Safety has, again, many, many agencies that would cover that. What are some of the restrictions on telemarketeers? What is the cooling off period for door-to-door sales? Well, telephone marketing is, we talked about, almost everybody's been hit with this. And they have robocalls that will call anytime, day or night, play a recorded message, not even done by humans. In other words, electronically, just randomly going through, or not randomly, but going through each phone number and calling. And those are now illegal. So you cannot use that automated calling and play pre-recorded messages. Okay, again, in the commercial context, political side may be still happening. How about the door-to-door sales? Well, door-to-door sales were felt to be an area particularly ripe for abuse because of the fact that many of the people at home were elderly or had perhaps other disabilities. They're a captive population, and so this particular kind of sales door-to-door did not allow comparison. It was kind of no-escape captive audience. And so they formed a cooling off period. So there's a 72-hour cooling off period, which means that if you purchase under these circumstances, then you have that length of time, 3 days, to determine that you don't want it and cancel it. Okay, again, that's only for the door-to-door sales. It's not something you go out and purchase yourself. Okay, what consumer credit issues led to the many credit protection statutes, and what's a guiding principle in the Truth in Lending Act? Well, the reason we have this large array of credit protection statutes is because the industry over time was noticed to be discriminating against women. It was also taking unfair advantage in its collection practices, being harassing. There were some problems in how credit reporting was done. So there were a number of different problems that these statutes were passed meant to correct. One of the major ones was the Truth in Lending Act, and this is basically a disclosure statute, as many of them are, meaning that the information has to be given to the consumer about what they're being charged, when they're charged, etc. All of this information about the loan or the extension of credit has to be provided in a form, an understandable form, upfront, not buried where you can't find it. So many of these consumer protection statutes, like TILA, are disclosure statutes, meaning that you have to be given the information so that you can make a reasonable choice about whether to avail yourself of this particular transaction. Okay, what is the difference between fee simple and leasehold ownership? Where can you get information about residential landlord-tenant law in Hawaii? Okay, you recall these are both possessory interests in real property. In other words, you have the right to possess it. However, the fee simple means you own it, so to speak, free and clear, absolutely own it. And leasehold means you own it for a period of time, for the period of the lease. And as we talked about in Hawaii, we have leasehold residential property, not that common in other states with the exception of Maryland. Now, if you have questions about residential landlord-tenant code, we have an agency that handles that specifically, and that's the Department of Commerce and Consumer Affairs, and there is an Office of Consumer Protection within that. So if you are interested in that, there's a lot of information on the website how to get hold of their publications and their personnel. Okay, well, we are going to look at international law. So you recall when we first got together, we described how our system of law in the United States and Hawaii differ from international law, and we're kind of coming full circle now, and we'll be taking a look at international law and fitting ourselves back into that and seeing how that interacts. So we'll look at the sources of international law. We'll look at international customs, international agreements, international organizations, and just touch on international dispute resolution. Okay, so international law is law between the nations. So we distinguish it from national law, which would be law of a particular country. If we talk to foreign law, we would be talking about countries other than our country. If we talked about transnational law, we might be talking about different issues that affect different countries. And if we talked about supranational law, we would probably be talking about an organization that affects or a grouping of several states. For example, the European Union. Okay, but when we're talking about international law, we're talking about the interaction between different countries, and we may be talking about the interaction between their citizens. So, public international law is the law affecting the relationship between states, nations, countries, and private international law is the law affecting individuals in those countries doing business with individuals or entities in other countries. So we're talking about state versus state is the public, and private is different entities within the states operating with each other. We'll talk a little bit about both of those. Now, if we use the term state in the international arena in the same way that we use nation or country, but to be a nation, we're talking about being a sovereign nation. Sovereignty is the ability to rule oneself, put very simply. But to be a sovereign nation, you need to have territory, you need to have a population, you need to have government, and you need to have the capacity to engage in diplomatic or foreign relations. So if you look at this listing, you can see that some of our sub-entities, in other words, in the United States, our states would meet most of these, but they do not have the capability or the right to have their own foreign relations because our federal system, that right is entirely with the federal government. So only the United States as a whole has diplomatic relations with other countries. An individual state does not. So for the same reason, when we're talking about sovereignty, we are talking about, we're not including territories or other groups that have not been recognized. Okay, so now the three major sources of international law: international custom, treaties and international agreements, and international or intergovernmental organizations. So these, in some regards, look a little bit like what we saw when we looked at our own United States law. So when we talk about international custom, in one sense we're talking about something rather similar to our original common law. So it's the way we've been doing things for a long time. When we're talking about treaties and international agreements, we're talking in essence contracts between countries. So hard to really analogize that to legislative action. And then international or governmental organizations, again, this is by consent. So we'll see that when we're talking about international law, we're talking about something that's different in some important regards than when we're talking about national law, because we don't have an enforcement body. We don't have someone that can enforce international law, for the most part, in the same way that we would enforce national law. We'll talk a little bit more about that, but how do we enforce our national law, or United States law? Well, there's a variety of mechanisms, and essentially the government, our government, would enforce those laws. They have power of sanctions, monetary, imprisonment, etc. And that's something that, for the most part, is lacking internationally. So we'll take a look at that. Okay, so when we're looking at international sources are international customs, treaties, and IGO. So IGO is our abbreviation for Intergovernmental Organization. We might call them international organizations, but the preferred term is Intergovernmental Organization, and this shouldn't be confused with another term you may hear in this arena of NGO, for non-governmental organization. And NGOs are the international equivalent, for the most part, of what we would consider to be charitable organizations, not-for-profit organizations. So this might be Amnesty International or some other organizations, particularly those associated with the UN, which do charitable work or that type of thing. Okay, so let's look at some general principles. And we can boil this down to say that all nations are considered to be sovereign. In other words, they have control over their own affairs. All states are meant to be equal. We do this and mean this in the legal sense, and certainly when we're talking about General Assembly votes in the United Nations, that's true. The way a state becomes recognized or a nation becomes recognized by the international community is by recognition. So other states decide that this is in fact a state. They extend diplomatic relations with it, and now it becomes a state. So you see every now and then there will be territories that civil wars and that sort of thing, and the question of whether or not we end up with a different state or different states, such as the breakup of former Yugoslavia, again depends on acceptance by the international community. And then the laws that we have, other than customs that everybody accepts internationally, the new laws have to be agreed to by consent. So again, we'll talk more about this no enforcement, but what we're talking about is everyone has to agree when something new comes in, and that's again the treaty process and some other processes. But it cannot be imposed because, again, when we looked at one of our first criteria, it was sovereignty. So who is it that's going to impose a new law if it's not by consent? Okay, now in recognition, we're talking about existing states will recognize a new country. Again, we saw this in Yugoslavia. Several countries came out of that. So there are these realignments that happen. There are nations that used to be territories that have been recognized. They've been granted independence from the original colonizing power. And the way, again, that they become a recognized state is that people extend diplomatic immunity, diplomatic recognition, diplomacy, and they are permitted to join the United Nations and other types of IGOs, intergovernmental organizations, and this gives them a legitimacy in the international community. Okay, again, the idea of rules by consent means that we will only be bound by what we agree to be bound by. So we use diplomacy, and this is an area of the kind of the international common law or the cultural background where we have diplomatic immunity, where we accept that an embassy is in fact considered to be the soil of that foreign country. Other agreements that we have are less formal sometimes, such as the use of English as the language of international aviation. So regardless of the country, in order that the pilots and people speaking different languages and the air traffic controllers, English has become that language. Now again, many of you may recall that originally the diplomatic language and kind of the international language was French, and we actually refer to that as the lingua franca, meaning the language of choice used between different people with different languages themselves, and now that's essentially become English for the most part. Okay, so the most important doctrines we have that are part of our international culture are sovereign immunity, comity, and active state doctrine. So we'll take a quick look at those. Okay, sovereign immunity essentially means that the nations that are sovereign are not subject to the jurisdiction of U.S. courts. So our courts cannot drag in the foreign countries for their own acts as a government. Okay, now there may be contractual things, there may be claims against them for torts and that sort of thing. Those are some other issues, but in general, we recognize sovereign nations as not subject to the court. Now, again, remember that this doesn't include territories, colonies, and things that are not state, because to have sovereign immunity, you would need to be a sovereign nation or have sovereignty. The idea of comity is that we will, in general, give deference to the laws and the rules and pronouncements of other countries as long as they do not differ from our own substantially. So if they're consistent with with our law, then we would recognize them and their judgments, etc. So again, this would often be handled by treaty, so you are aware of extradition treaties and that sort of thing. But for example, if a country did not have capital punishment, they would probably not allow one of their citizens to be extradited to a place that did, because that would not be consistent. And this also applies to other types of laws. That was just an example. Okay. So the active state doctrine essentially means that what a country does within its own borders is its business. So we will not be attempting to apply our laws in their country if they are doing a governmental public act. Now, obviously, this is always in the news when certain countries are doing things within their borders that we feel are violations of human rights or violations of other fairness and justice, etc. But in general, the active state says governmental acts, at least, are not subject to our outside laws. This has been the justification for countries taking property within their state that belongs to citizens of other states. So this happened much more in former times when nations arose that had been colonized previously, but it has happened even as close as Mexico, that took over some drilling, etc., gas exploration from some of the petroleum companies. Okay, so if expropriation is a government act to take over the foreign company or investor property within that particular nation. And if they do that and give prompt, effective compensation, we call it expropriation. If they do not give compensation, then it's considered confiscation. So if they don't give any value for it. International law also recognizes nationalization, and this is when an entire industry is taken over by the government. So it's nationalized. In other words, it is made government owned. And many countries do this with respect to what they consider to be strategic or critical industries, such as oil and gas, that sort of thing. So again, many countries have a government-owned petroleum company, and it's in the past they have taken over petroleum interests of foreign companies within their borders. Okay, so when we look to customary law, and again, a loose equivalent to the common law that we've already looked at in our country, we look as to how the nations are doing this. So we look at whether or not it's a generally accepted. It doesn't have to be universally accepted, but we look to see whether it's generally accepted by what we consider to be civilized nations. We look to see how long we've been doing it that way, and we look to see that most countries agree to the basics of it, that we're doing it in a similar way, a uniform way. And many of these will be long-standing, centuries. Some of the ways we do things have been done centuries, so there's a long-standing history of them. And this provides a lot of context for interpreting other types of agreements if it's an understood thing that all countries have agreed to. So what would be some examples of this? Well, the idea that territorial waters extend 3 miles. Okay, and there's some other distances that are included in our basic admiralty out to 12 miles. Now, some countries claim fishing rights out to 50, and those may or may not be accepted by other countries. So there have been various disputes about how far out the rights go. And so if there's not an agreement, then it may not be considered to be customary, and that may be subject to dispute. So we will frequently see arguments about fishing rights. There's a lot of controversy about who has rights to various minerals in the seabed that are not attached to a country. So they're not on somebody's continental shelf, but they're in the deep sea. Obviously, countries with more technology can exploit those, and other countries cannot. A lot of issues there. But when we're looking at customary law, we're looking at whether people have agreed to these conventions. Now, very frequently, as happened with common law, where we saw in our system common law eventually ends up in a statute and it becomes codified, for example, in the UCC that codified warranties that previously had been in common law. Same thing happens in international law. So we will have customs, and they will be incorporated into some treaties that everyone agrees to. So although they started as custom, now they are part of the treaties. They are by consent and by agreement. So that would include some of our diplomatic interactions that have been codified in the Vienna Convention on Diplomacy, and the injuries that are involved in international flights. There's a Warsaw Convention, probably on the back of your plane ticket. You may see some reference to that. So some of these were, in the past, might have been customary, but now are part of the agreement, the consent. Okay, now we have all different names for our agreements and treaties. Okay, a treaty is between foreign nations, but a lot of these we refer to as conventions, protocols. So you will have a protocol for the environment. You will have a convention that we just talked about, the Warsaw Convention. So there may be various different titles for these agreements between countries. Now, they're going to be binding where? They're going to be binding on the countries that agree to them. So you've undoubtedly heard of the Geneva Convention about how we treat prisoners of war. And the people that are subject to that are those that have agreed to it. Now, they can be treaties and conventions, etc. It can be bilateral between just two countries, or it can be multilateral where a number of countries sign on. Obviously, the more countries that sign on and agree, the more oomph it has, the more validity it has internationally. And over time, if enough countries are buying into this, it may be considered to be become part of international custom. Now again, to be custom, it needs to be fairly generalized. In other words, it needs to be have quite an extension among the countries, but it doesn't need to be unanimous, so to speak. So there can be things that are considered to be international law, even though one or two states or nations will not accept it. Okay, and we talked about one of the third major areas of international law. One of the major sources would be coming from intergovernmental organizations. Now, the main area here would be the United Nations, and so most of you are familiar with the United Nations. The idea of a government, so to speak, or an organization representing all the countries had actually come up in the First World War, the League of Nations, which never got off the ground. The United Nations came directly after World War II. Now, there's an awful lot of other different intergovernmental organizations. We'll talk very briefly about the European Union. Again, it's many years in the creation, maybe 30, 40 years from the early attempts to get together. Talk about the International Monetary Fund, World Bank. There's the General Agreement on Trade and Tariffs, World Trade Organization. Again, These are referred to generally as IGOs, intergovernmental organizations, and the pronouncements and decisions, etc., of these groups may be considered to be international law if accepted by sufficient people. In addition to these areas of the law, we'll briefly talk about the what we call the World Court, and it recognizes when it talks about sources of law that will be applied within the court. It also talks about some other areas such as pronouncements of legal experts. So again, in the civil law area, they rely very heavily on legal commentators, experts in the area. Not so much in our common law system, but certainly internationally we can look to those sources as well. But not really to the same level of the big three of custom treaties and agreements and international organizations. Okay, so again, the United Nations is the major organization. It is not a world government. There are some things that it does not have. So again, there's a lot of material on the United Nations. We're just going to touch on it briefly. There are quite a few subparts. The main one we typically hear about is the General Assembly, and this is all of the countries. There are a few exceptions, Switzerland, a couple of other nations, but most of the countries in the world have been admitted to membership in the United Nations. Again, we talked about some territories that we're not yet sure if they're countries yet, so they would not be admitted. There was also there's dispute as to which China should be there. Currently it's People's Republic of China. Taiwan is not there, but there was that kind of dispute. So there have been issues over the years about who can be or should be a member of the United Nations. And again, it has to do with the recognition by the international community. So a particular country can extend diplomatic relations to another new forming country, but until it reaches critical mass, they would not be admitted to the United Nations. Now, the other major part of the United Nations is the Security Council, and there are 5 permanent members of the Security Council. And again, you can read the material. This is historically based because it happened right after the World War II. So these are the allies. So we have China, France, Russia, United States, and United Kingdom. So 10 other members are elected by the UN for 2-year terms. So we have 15 members, but the 5 permanent members, they have the veto power over action. So this is really where the governing part of the United Nations is. And again, historically bound, some major countries not part of the United Nations, such as India. There's some real questions about whether it makes sense now to have those particular members, all of that sort of thing. So these are some issues that keep coming up with it. Okay. Now, one of the problems that we talked about with the United Nations is if they come up with determinations, how do we ensure compliance? Because in our own system, obviously, we have the power of sanctioning. So our government can sanction people within our country if they do not comply with the law. This is not true with the United Nations. So how do we ensure compliance? Well, we can extend economic sanctions, we can boycott, we can embargo, and in certain instances we may use coercion. But for the most part, the United Nations is not going to be using force with other countries. The sole instances are for peacekeeping. So the UN does get involved in peacekeeping, but certainly nothing on the commercial or business side is going to result in any kind of sanctions of the type we would see within a country. For many years during the Cold War, the UN did virtually nothing in peacekeeping simply because there was a standoff between two of the members of the Security Council. And again, that veto power makes it difficult to come to consensus on many of the enforcement kinds of activities that would be involved. Okay, so again, how do we try and ensure compliance or enforcement? We use trade if we can. So for many years when South Africa had apartheid, in other words, enforced segregation, other countries would not trade with South Africa. They would not allow them to be part of various organizations and even activities, Olympics, whatever. So there was that kind of informal kinds of pressure that can be brought to bear. And of course, economic sanctions can be effective in some instances, but not in others. You recall, if a country has unlimited resources, for example, oil reserves, pretty hard to effectively use an embargo when there's a lot of petrodollars involved. Okay, now we do have an international court, okay, and this is The Hague in the Netherlands. The International Court of Justice is also referred to as the World Court, but it has some substantial differences from the courts that we're used to, that we've discussed in our own country. So the main difference is that only states are parties. So this is a court for interactions between countries, not people in the countries, and it also is by consent. So the only time that you will appear before the court is if you have, in essence, volunteered to come to court. So if you decide that you want to have the court make a decision in a particular issue, then both sides can agree and it can go to the International Court of Justice or the World Court. Otherwise, if one party does not submit to jurisdiction, again, there's no way to force them to be a party to that jurisdiction. Now, there's also material on the International Criminal Court, and this gets involved in war crimes and other activities. But again, this is by consent, and many countries have not signed on accepting the World Court, the jurisdiction of the World Court, partly because they may not want their own citizens to be subject to the World Court, Criminal Court, which does deal with individuals. And in fact, the United States has not signed on to the Criminal Court. So there's additional material on that. But again, the problem here is the jurisdiction, the inability to cause people to come to court, which is obviously the sanctions are what makes the court system very effective as the arbiter in our national courts. Okay, so again, the concerns we have the World Court is the inability to enforce its judgments, or to even enforce people showing up, in other words, to secure jurisdiction over people. More and more countries are using the international court, so it may be that over time it becomes a more effective instrument if countries feel pressure to submit to the jurisdiction because of the other, what the other countries are doing. So it's possible that it will build up a more effective sense than it has now if it becomes part of the norm for countries to submit their disputes here. Okay, again, we said there's an awful lot of intergovernmental organizations. Probably the one that has gone the farthest and has become more nearly a government of countries would be the European Union. And this is 27 countries. It started out back in I believe, the 60s. These countries were called the Common Market. So initially they were getting together to break down trade barriers to make it easier for these countries in Western Europe to trade with each other. They had different monetary systems. Some had different weights and balances. Most of Europe was metric. United Kingdom was not. So these were early attempts to get the trade going, and this has developed into a full-fledged regional organization, and you could say regional government. Okay. You can see it's quite substantial, 500 million people, $13 trillion economy, and they've come up with a number of things that have broken down the barriers, broken down the borders, so to speak, between the countries. So you've undoubtedly heard of the euro, which is the currency now used by a little more than half of the countries are using the euro. There is a passport, so you can travel freely between the countries. So there has not exactly United States of Europe, but a fair number of steps along that way to where it is functioning as a union, as a United States of, so to speak. Not yet there. A lot of concerns still among a lot of the people about losing their national sovereignty, their national identity. So quite a long way, but actually probably a more successful model because it's dealing with a smaller group of countries that are more similar than the UN in terms of becoming a world or regional government. Okay, again, as noted, it has its own parliament. It does have its own court that the members are bound to, but there's still a lot of tension between all the good effects of the cooperation and the diminishing of the national sovereignty, and concerned about that. Not only cultural traditions, but other things are concerned here. Okay, now we talked about this up to now. We've been talking about the public international law, in other words, the law that governs the interaction between the countries. But on the business side, we're really interested in when we're dealing with someone else, a company or an individual in a foreign country. So we're talking about the private international law. In other words, the law that affects that transaction, not our country and the other country. So an awful lot of actually the public law, however, would certainly concern our transactions. So we talked briefly about the Convention for International Sale of Goods. So this is sort of like a UCC for all of the countries that have agreed. So it's to help our transactions with other countries in the same way that the Article 2 sales made sure that when we're dealing with different states that we don't have a problem with our money and our credit and our transaction. The Convention for International Sale of Goods is a very similar type of instrument, type of agreement. There are some differences there, different assumptions, etc., but it serves the same function. Certainly, if we're dealing internationally, we would need to become familiar with the provisions of CISG. Okay, well, let's look at a couple of areas individually to get a feel for this. So we've talked about intellectual property, and internationally there's serious concerns with piracy, counterfeiting, and imitation. So with countries having different rules about what can or cannot be done within the country, obviously there will be certain countries that would tend to be the place that counterfeiters or pirates would go, since if they have laxer intellectual property, copyright, patent, trademark rules, that would be a place that they would not be violative of the place they were in. So certain countries have gotten a reputation over time of being locations for people that are pirating and counterfeiting goods. Obviously, since many companies are dealing internationally, that's of concern. So there have been a number of agreements and conventions to protect intellectual and industrial properties. The Paris Convention is a major one here, but there are a lot of other agreements on various aspects of intellectual property. Now, these will differ from the United States. The United States, particularly the copyright, is much longer duration than is recognized in most of the rest of the world. But if you are publishing internationally, you would want to make sure that you avail yourselves of the protections and to the extent you can in whatever places that you are selling. Okay, there are a lot of other things about international trade that we want to take a look at. So particularly the same kind of concerns we had about when we were talking about antitrust and talking about preventing monopolies or preventing unfair trade practices in restraint of trade, that sort of thing. We have the same concerns internationally, even more so because particularly with inexpensive labor, it's certainly possible for other countries to undersell and undercut industries, even if they're, in essence, doing this fairly. In other words, they simply have much lower costs, and so they are able to produce goods at a much better rate. Okay, so we may have protective tariffs, okay, simply to protect our own industries. And we talked a little earlier about if we consider an industry to be strategic, then we would want to protect it. So many countries would protect their steel industry even if it was not very efficient compared to other countries, because that's something that we consider to be strategic. We might protect our oil industry, and we just talked about a country may nationalize other countries that are doing oil exploration or oil exploitation in their countries. So we're going to have protective tariffs, in other words, taxes and duties, to protect those. Now, one of the things we are concerned about internationally, though, is dumping. And what dumping means is, in essence, it's selling below cost or government subsidy that allows a foreign company to undercut our industry by bringing in goods at what is considered to be an unrealistic low rate. So we can have anti-dumping duties, which means that we would add tariffs to those or add taxes to those to make sure they did not damage our own industry. Obviously, in developing countries, the government may get involved in assisting production because they're trying to build up the industry. But if in doing that, we feel that in our country that they're damaging our industry, then we would protect that. So again, we have these various mechanisms, quotas, tariffs, duties, to try and protect our internal industries from outside competition, and particularly the unfair competition, the dumping or selling below cost, that sort of thing. Okay, another question we have is not only what the laws we're subject to in a foreign country, but how about are we subject to our laws? What's the reach of our laws into a foreign country? And again, we've talked about this a little bit when we talked about Foreign Corrupt Practices Act. So you recall what that was. Foreign Corrupt Practices Act said that an American company may not pay a foreign government official to obtain business. So that's considered bribery. It's considered bribery in the U.S., may be a standard way of doing business in that particular country. But for our companies, they are not permitted to do that because then they have violated U.S. law, even though they're doing it outside of the U.S. So that's an instance where our law is going to affect what we do internationally. It reaches out. Okay, another area may be the international tort claims. So there are questions of whether or not American companies can be liable in U.S. courts for things that they are doing in another country. For example, if they are using pesticides or in some other product that is damaging people in another country, do those people have a right to sue our companies in our country? And again, there's some material on the website. There's some interesting things happening in this area in the international torts, because American tort system is considerably more developed and, shall we say, liberal or favorable to injured people than in many other countries. So if people can come to U.S. courts and avail themselves, they will, because they may not have that protection in their own countries. Again, we've talked a little bit about that. For example, our child labor laws are quite different. A lot of our employment laws are a lot different, and so products made in other countries may be made in a way that we have concerns about in the U.S. Okay, so we talked about multinational corporations, and so those are corporations doing business in a number of places. These are of concern to the international community because of their reach, and in one sense, these can be effectively global monopolies, or certainly a monopoly or single player in those countries. So there's some goods and bads, obviously. The multinationals certainly have the capability of improving the technology in those countries, generating jobs, contributing to the economy, etc. But there are concerns if they are, in fact, exploiting the labor, taking resources out, that sort of thing. Okay, now, when we are dealing as an individual or a business in another country, there's a number of things that we're going to need to get up to speed on, because we may be familiar with operating in the U.S., but we need to be a little more aware of what's going to apply to us in those countries. And we talk about conflict of laws. So conflict of laws means that we need to determine whose law is going to apply in a certain circumstance. So if we're dealing with another country, there's always the question of whether that country's laws applies or ours, particularly if the transactions or the activities are happening more than one place. There would be a question of which law applies, and that's going to be important to us. Now, we also have to remember that the different national legal systems are foreign in more ways than one. In other words, they operate in different ways. In many countries, the government itself is going to have a much more central role in business than we do. So the government may have much more control over the companies that work there, and they may even be governmentally owned partially countries. So that has a serious effect. It's not like we're dealing with just another counterpart that's just like we are in another country. And again, remember, just like we talked about at the very beginning, the laws are very, very different. So the role of courts is going to be different, and the importance of the different types of laws, the different types of regulations, that sort of thing, are going to differ in the different legal systems. So let's just do a quick review of what those systems look like. Remember, we're common law. What does that mean? It means that the civil law the court-made law, the judge-made law is extremely important to us. And so those interpretations are critical. And in fact, the court can declare a statute passed by the legislature unconstitutional. The power found in no other system, only the common law system. Okay, how about the civil or code law? Well, that's our friend Napoleon here. That's based on Roman law, Napoleonic code. Very important from the statutory point, the law that comes from the legislature. And this is where they use legal experts. So the courts don't interpret, the legal experts and the legislators interpret. So a different system. Okay, the socialist system. Again, Soviet Union is gone, but a lot of this still remains. This is very administrative system, very top-down, a lot of government involvement here. And so there are still countries very much in this model. And then finally, the religious legal systems. Many of these are Islamic, but there are some other countries that are different religious bent. Most of these are Islamic. And so recall there's very little distinction between religion and law here. Okay, so what do we need to look at when we have an international contract? Well, not only do we have conflict of laws, we may have conflict of language. So do we have an official language? Are there two official versions? Choice of forum means where do we take our problems? Do we decide in advance that we will go to certain courts, certain places? We can apply different law, so we can select which law we want to apply, and in many instances that will be accepted. Remember, we had some contractual discussions about what happens if the contract can't be done because of impossibility and that sort of thing. So we may want to put those provisions. And we're going to want some civil dispute resolution, because many countries do not go to court. They go to arbitration, they go to mediation, etc. That's going to be much more familiar to them, and that's going to be probably the way they want to handle these. And some of the international dispute resolution mechanisms are quite well advanced. Okay, just thought I'd throw this in, just show a little interest. How many lawyers per population? Again, you can see this is very slanted because all of the top ones are common law jurisdictions. Most countries do not have use lawyers in the same way, do not have jury trials, etc. So maybe a little skewed, but again, just throw it in to indicate to you that the ADR, the dispute resolution, is much more of a force in international work. Okay, so we have taken a look at international. I hope we've brought it home. Hope we can now see the context of how we fit in the system. Again, kind of bringing us the great wheel back to sort of where we started. Again, like many of our areas, there's just a whole lot of material that's on the website. I hope you'll take a look at that. Again, we just barely touched UN, European Community, etc., and a whole lot of other factors that if you are going to do international business, it's worth a whole course of its own. But there are some resources for you there. Okay, well, this has been enjoyable. I hope that you have a good feel now for business law. I hope you feel a little grounded, and I hope you'll be able to at least know where to look when you have questions or problems. Again, I've got some sources on the website for you as to additional websites, places to go if you have questions about various things, and I hope that will be useful to you. So this has been Carol saying, it's been great. Aloha. I will see you around.